Good evening. My name is Jessica Saxon. I'm a civil rights advocate and litigator from Washington, D.C. I'm here to provide notice to council tonight. This is in accordance with USCS Rules of Civil Procedure as well as Rule 17 and Rule 20 from the United States Supreme Court. The Constitution for the United States is the overarching that we all must follow. There's no one here would disagree with that. States cannot enact their own alternative legislation and substitute it for the guarantees of the Constitution. That would mean that your state laws are more powerful than the Constitution, and that is simply illegal. Clause 1 of Amendment 5 to the United States Constitution says that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. Unfortunately, the state of Kentucky has enacted in its alternative legislation an inferior law that provides your prosecuting attorneys and police officers to charge by way of information as opposed to indictment, and that is simply illegal. There are two areas of the Constitution that reinforces what is called an emolument violation. That's when you pay a public official to break the law. The first is Article 1, Section 10, and that's where it says that no state shall create any law that shall impair the obligation of contract. Your police officers, your prosecutors, your judges, they are all under a contract to perform based on the oath or affirmation that they took to support and defend the Constitution of the United States of America. The second area in the Constitution that reinforces this issue regarding an emolument violation and paying public officials to break the supreme law of this land is the 14th Amendment, and that's where it states that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. Privileges and immunities of United States citizens are at a minimum those that are enumerated within the Bill of Rights and the first 10 amendments. The state of Kentucky has enacted in its inferior constitution a law that is permitting your public officials, your law enforcement, whom you all pay, to violate the Constitution. As a result, we have an inordinate amount of people here in prison illegally and unconstitutionally in this state. Mr. Tanawah Downing is preparing to litigate this issue at the United States Supreme Court on behalf of more than 700,000 people currently incarcerated across America illegally and unlawfully. I'm here today to provide you notice that you cannot continue to pay public officials to commit crimes against the constituents of this county. I'm making you aware that paying people to disobey the law, the supreme law of this land, your law enforcement officers, your judges, your prosecutors, that is an emolument violation, it is a crime, and it is illegal. So I'm asking you, please, consider what I've said tonight, take a look at Clause 1, Amendment 5, confirm what I'm saying to be true, and then direct your public official to act in a lawful, constitutional manner that is consistent with the Constitution. Thank you so much. I have a notice.
Thank you. Next, we'll have Mr. Tanawah Downing. Welcome.
So my name is Tanawah Downing. I'm the civil rights litigator that Ms. Sachs was just talking about. I'm from Washington, D.C. as well. I need to step up and provide a little bit of clarification so you guys can understand what just happened and how do we move forward and what we're actually asking from you. So I have approximately 8,900 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment in violation of the Constitution of the United States from right here in the state of Kentucky. Many are from within this city itself. So these affidavits, they identify two different crimes, right? First is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute says that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. The second crime is Title 18 U.S.C. subsection 241, which is conspiracy to deprive of rights. What that says is that when two or more persons conspire with the purpose of depriving any person of any rights secured by the Constitution, commits that crime. So again, if you're police officers are going out and relying upon an inferior state statute that permits them or directs them to abridge their obligations codified in the Constitution of the United States and bring the incorrect charge and instrument, they are acting unconstitutionally, and you guys are paying for that work to be done. So the laws of criminal conspiracy with regard to public officials, what it states is that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of commission of the same, neglects or refuses to do so, may be joined in suspending the action. So having been provided with this notice, letting you know that these actions and unconstitutional crimes being committed, we would ask you to please, let's step up, discharge the duties of your office, and help us fix this problem. Because the alternative is that we will have to start converting these criminal affidavits into criminal complaints, and we don't want to go down that path, and you guys don't want us to either. So I know that you're going to go and you're going to ask your attorney as soon as we're done here whether or not what I'm saying is true, and that attorney is going to say they're going to point you to a case from 1884 from the United States Supreme Court called Hurtado versus California. And before you choose to rely upon that as the foundation, I must remind every one of you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution. That must be done by authentic acts of the people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate. We know that because Clause 1, Article 1 says all legislative power is vested in Congress of the United States. So I pray that you guys will decide to do the right thing here. I understand this is a very difficult and tough decision. You guys are going to have to choose between whether or not you're going to follow a judge-made ruling or the supreme law of the land, Constitution of the United States. But the object to which your fidelity is bound is to the Constitution of the United States. So I'm going to go ahead and leave you with this by saying that the United States Circuit Court provides the determination as to what is or is not an abuse of discretion. And it identifies a two-part test. The second part of that test is that any erroneous view of the law is an automatic abuse of discretion. An erroneous view of the law would be in your legal contemplation that the lowest form of law, a judge-made ruling, is in legal contemplation superior to the highest form of law. That would be an automatic abuse of discretion. Thank you guys so much. God bless.
Thank you.